Good morning, ladies and gentlemen, colleagues. I am Maira Čentaricka, head of the State Expertise Office and moderator of today's event. It is a great event, a great opportunity to see you all. On the 13th of September, a few years ago in London, the court made a decision where the verdict was based on the expert's opinion. First time in history. So it's an anniversary today. We will have a fruitful discussion, conclusions that we will bring with us, and good contacts. When the court administration set the date, the 13th of September, we didn't know that this was the first day when an expert's opinion was used in court. And therefore, to open the seminar, I would like to invite Erik Skalmeyers, Prosecutor General, for the opening remarks. Good morning, participants of the conference, guests, lecturers. Thank you to the organizers for this honor to make the opening remarks. The topic of today's conference is very relevant. It is redundant to emphasize the relevance of this topic again, as we have professionals gathered here who know this area very well, who understand the importance of it, but it is never too late or too much to learn something new. And today, I am positive that you will gain lots of useful knowledge that you can use in your future work. Practice has shown that even prosecutors and investigators with a substantial work experience commit mistakes in their work frequently, particularly in relation to expertise. On the one hand, they do not know well what kind of expertises can be asked for and what can be found by experts. This is one aspect and one issue which must be solved, and it can be done by raising the qualification of these professionals. And on the other hand, something that takes time and is learned only with time is to establish the threshold of evidence that is necessary without committing unnecessary activities. Some of these unnecessary activities are not costly. A few extra witnesses will not do any harm, but expertise which is unnecessary, and experts' opinion, or if expertise is just one of the evidence used in the court, then it is erroneous to assume that experts' opinion is above all the other evidence in the court. Then our legal professionals must understand this and have this perspective. But in practice, we've had prosecutors who have asked for expertise that they could do without easily. For example, a medical professional has taken a bribe. There are two witnesses. The culprit does not deny it. It has been established, and yet an expertise has been asked for, and the results can be available only in a year. And this expertise was questionable, in fact, as it was just an additional factor, but the proceedings are delayed by a year, and the experts are burdened or employed unnecessarily, and of course they have to be paid from the state budget. We cannot see any advantages of this expertise. The witnesses are not likely to change their statement. The defendant is not likely to change his confession. He has admitted that he has taken the money, but the prosecutor says, I need this expertise for the court. But then we could tell him, if the court asks for this expertise, then it must be done. But if you are just trying to do it in case, it is not necessary. This is why these kinds of trainings are of great importance for us to work on more effective and professional level to provide for fast and fair decisions in the legal proceedings. I would like to thank everyone for participation. This conference is organized in the framework of Project Justice for Development, which is financed by the European funds. And now Mr. Edvins Balševics, Director of Court Administration, will have the floor for opening remarks as well. Good morning, thank you. Honorable judges, prosecutors, experts, ladies and gentlemen. The judicial policy is very important in the development of the economy of a country, and effective work of the courts in investigation of economic and finance crimes particularly has an essential impact on the environment of commercial activity in the country. I have a great honor to open the conference organized in the framework of the EU Finance Project Justice for Development, which is dedicated to the possibilities in the work of experts in the legal proceedings. The expert's role will be viewed in the context of other evidence. In this conference, there is a plan to discuss the balance of the costs of expertise with the cost on the importance of expertise in the legal proceedings. Experts' role is growing in the legal proceedings. If the facts found by the experts are grounded scientifically and based on evidence. At the same time, the court and the society raises demands for the qualifications of the forensic experts and for the quality of their work. The higher quality expertise they can provide, the higher quality rulings the courts can make. And it is important to learn from the foreign practice to raise the standards of work which would be compatible with the international standards in this work. An experienced expert from Latvia has once said that the courtroom and evidence are linked together in a chain, and all the segments in the chain must be equally strong, which can only be achieved in the fruitful cooperation of the court with experts. The more knowledgeable the professionals involved in the court proceedings are, the better, the higher quality work the court can provide. I would like to thank the Latvian and foreign lecturers, all the participants, for being present at this conference, as well as the organizers for the work they have invested in organizing this conference. Celebrating the centenary of Latvia, we will pride ourselves in all the people of Latvia who are making Latvia safer, stronger, and more beautiful. Thank you, and have a successful conference. And now I would like to give the floor to a very knowledgeable professional who has been involved in this process since 1997. He has been active in various working groups related to the amendments of the criminal procedure. He is an expert on the forensic expert's work. He has his opinion on the expert's work and things related to it. It is Juris Stukans, judge, deputy president of Riga Regional Court, president of Criminal Case Division of Latvia, and the topic of his presentation is forensic examinations in criminal procedure.
Labrīt. Es bišķiņ apmulsu, jo mēs...
I feel a little confused as together with my colleague seeing who is announced as the next speaker, we realized that the program has been changed and someone else is supposed to speak here, as you have praised me too highly here. Now, the facts, of course, correspond to what it says here. In my biography, indeed, it is true that I have been working on the criminal cases for many years, and I have been trying to raise those issues which are related to reviewing and hearing criminal cases in the court. Our prosecutor general said the most essential things. He emphasized the two main issues which are most relevant today and which explains why our proceedings are often work-consuming, labor-consuming, and extensive. Yet the prosecutor general concluded with this statement that we expect and the law demands fair judgment. Therefore, each individual, the society, has the right to see and understand why the court ruling is what it is. I will start my presentation by a brief definition. I did it consciously as we have foreign experts participating in this conference, and it would be very interesting to see how this issue is regulated in their respective countries. The criminal procedure law states about expertise that it is an investigative action carried out by experts, and the content is to find out facts relevant for the criminal procedure as well as circumstances relevant to the criminal procedure which can be proven. This is a simplified translation of the definition, of course, and the definition itself is not complex, but it mentions very important conditions when we can consider expertise being an expertise in the criminal proceedings. Most importantly, in my opinion, there is the aspect which is often disputed, is that expertise is carried out only when assigned by the prosecutor or investigator.
And here I would like to underline this point. There are cases when the defense submits a wide range of different expert conclusions. We in Latvia have independent experts, and there is an association of independent experts, and the defense can submit a whole spectrum of opinions from these independent experts. Right now, taking into account the practice of the Supreme Court, we have to accept these opinions and we have to assess them. However, from the point of view of the law on the criminal process, we can conclude that any person who has assessed something and written their opinion simply submits an opinion of a person, and it doesn't matter whether this person calls themselves a forensic expert or an expert at large or anything else. They're not an expert, they're just a person. And I hope that in the course of time, the attitude is going to change, and the Supreme Court will change their attitude towards documents that contain forensic research in their essence. Because what does it mean to assess the opinion of another person? In my opinion, the official opinion of another person could be used in a certain way. The defense can indicate that there are issues or imprecisions in the forensic expertise included in the case materials. But this opinion provided by another expert cannot be used to replace the official forensic expertise, only to indicate certain points. And of course, we understand that other people do this job not out of the goodness of their hearts. It is a costly procedure. It's time-consuming. And otherwise, we might create an erroneous opinion in a person that there are two experts, one independent and one official, and they provide different opinions. This creates confusion. Another important point, expertise in legal proceedings means that we are only studying the materials submitted to us by the prosecutor, by the advance of the process. And this creates some confusion as well, because we are frequently asked to examine some documents or some materials, and we wonder, why can't they do that on their own? But in accordance with the law, only the materials submitted by the advance of the process are going to be subjected to forensic expertise. And this is a very important point in our legislation. If another independent expert has provided an opinion on something, we have to ask ourselves, who gave them these materials and what materials they gave them? In most cases, they examine the materials of the case, and that is the task that the prosecutor is charged with, not the other party. The expertise has to be carried out in accordance with the procedure and in regards to the objects that require additional examination. Another important aspect that has been outlined in our legislation and should be examined further before we decide on forensic expertise. These are the grounds for assigning forensic expertise. There are grounds for that if specialized knowledge in crafts, industries, or a branch of science is necessary. Here, I invite you to pay attention to this phrasing. You have to find out important circumstances, and the advance of the process or the prosecutor does not have the specialized knowledge. Because in the previous slides, I have already highlighted the point about the circumstances that need to be proven in the course of the process. Associated facts remain facts. This means that we're talking about the object of proof and investigation. So you have to decide what are the important circumstances attached to the object. Here, this is determined by the qualification of the crime. What is its qualification according to the registry? Is it a robbery? Is it a murder? Because there are different criteria. When it's murder, you always need expertise. A few days ago, we had a case where it said that the expertise is mandatory, but I would say that according to the procedure, it was not mandatory in that case. When all the persons involved are determined and they provide full information, why would we need forensic expertise just to confirm the fact that it was a murder? That is the question. Perhaps we might need forensic expertise to determine the logical relationships between the events or between persons involved, but not to determine the fact of the murder. I believe that when we are examining murder charges, the determination of the fact of the murder can occur without involving a forensic expert. So the qualification of the crime is important, and the prosecutor should definitely know, or at least understand, what kind of crime they're dealing with. What kind of crime they're willing to prove later in court. What they're willing to go for. There's a third aspect I would like to touch upon. This is something I have been dealing with myself in different criminal cases. Unfortunately, in some cases, the prosecutors want another person, in this case a forensic expert, to answer the question whether this is a crime or not. However, it is only the prosecutor who needs to decide whether this was a crime and whether the raw materials for that. Professor Lieder, who is an authority on criminal process, wrote in his book that opinions of forensic experts need not concern matters that require knowledge in law, because this is something that in the competence of the prosecutor or the judge and not of the forensic expert. So you cannot exceed your mandate. For example, there might be crimes related to hate mongering. I studied criminal cases for the Riga District Court, and in all cases there is an expert opinion, and this expert opinion is provided by a person who is a so-called human rights expert, and this is called a forensic opinion for some reason. And there are conclusions that certain words or certain statements by persons involved are hate-mongering. I think this is wrong, because it's for the court and for the advances of the process to decide whether a statement is hate-mongering. Only they can say, the judge or the advance of the process, that something is hate-mongering. We just call things forensic expertise without thinking whether it is a forensic expertise. And what shocks me is that judges really rely on these opinions provided by experts, but the forensic theory does not support such methodology, and yet we see it in real practice. This is something that has been very stable and engendered in our day-to-day quarterly life. I think that this is something that needs to be eradicated and would require transformation of our mentality, but here I think that the advance of the process has to evaluate things on their own. Another thing I wanted to say, I would like to support the opinion of the Prosecutor General, Mr. Kalmers. In the initial stage, it is very important for the advance of the process to understand what is their goal. So what is the end game of examining this case in court? Right now, the role of the prosecutor is not as strong as I would like to see it. Because in my opinion, the prosecutor is the one who supports the prosecution in the name of the state. So this means that from the first day, the prosecutor should state quite clearly in writing what circumstances need to be found out and proven so that we can decide upon the further development of the investigation. Whereas the investigator should not be the one who's making decisions. The investigator should be just the executive officer for the visionary decision of the prosecutor. However, we know the real situation in Latvia. We have the reports of the State Control Department, and we know what's the difference. Time is running fast, and I need to hurry up with my presentation, but I would like to draw attention to another point. Who performs forensic expertise? Here, we should thank our moderator in person for adopting a new law on forensic expertise. It's a very recent development. It's been adopted in 2016. And right now, we finally have this document that clearly states that a forensic expert is a person who has the knowledge and who has been certified according to the procedure determined by the law on forensic expertise. So we have the official register of forensic experts who are approved and certified, and this means that the prosecutor just has no worries. They need to log into the registry, they can pick the expert they need, and they charge them with performing the expertise and providing an expert opinion. You will ask me, do we have experts in all areas? My answer is no, but the authors of the law have thought about this beforehand, and in Article 3 we have additional information that provides a loophole. If we don't have an expert in Latvia, we can seek them abroad. Of course, here is the nebulous matter of assessing the relevance of a particular expert from abroad, because there are no explanations as to how we are going to invite this foreign expert and to what purpose. But the law on criminal proceedings says that we can invite a forensic expert to court to check their qualifications. As far as I have seen and heard, the qualification check is very minimal. You are asked where you studied. You might bring copies of your diplomas. And, well, that's it. I think this is completely decorative and unnecessary, because if this is a person who is included in the official register of forensic experts, then there is no need for any other check. In my opinion, a proper check is a check by other experts that can truly evaluate the expertise of the forensic expert.
This will not be good news for the experts, but this is what Prosecutor General has said, and I also join this opinion. Previously, there were forms which were used for expertise. Simply the names and facts could be changed in the same forms, and now the regulation has changed. There are no required expertises required, even for bodily harm caused, and the prosecutor has to make the decision in each particular case. And if we take the criminal offense causing bodily harm, we cannot do without expertise in the case, as the liability is related to the degree of bodily harm. If you think logically, then this is the kind of case where expertise has to be provided for. Prosecutor General has also mentioned this issue, which is an important aspect for the prosecutor. Expert's opinion is a kind of evidence, one of the evidences. And only assessing the evidence and circumstances in the case in totality, something can be confirmed or doubted. In fact, the willingness has decreased presently to use polygraphs. This expertise, as the reliability has been questioned of this particular technology. And the decision of the Supreme Court also has ruled that the expertise provided by polygraph has to be assessed in totality and together with other circumstances and evidence. Perhaps the polygraph has ruled that the defendant has not lied. There have been cases like that. Nevertheless, the court has ruled that the defendant is guilty, and then the experts have been blamed who have been worked or related to this polygraph expertise, and so on. But whether we believe it or not, in a few years, the practice can prove to be contrary. I remember the case when in the USA there was a person who was sentenced for 30 years and put up with his fate, probably, and as soon as the DNA expertise became available, by carrying out the expertise, blood marks on an object left on the crime scene, it was found that he was not the person who had left the evidence, who had left blood stains there, and he was released after 30 years, and he was paid a compensation of about $30 million US. But perhaps it wouldn't be possible in Latvia. Thank you for your attention. Thank you, Mr. Stukans, for this overview of the criminal procedure. And it is true, indeed, that DNA analysis turned many cases and truths upside down. This was not the only case when people sentenced for murder turned out to be innocent, but this may happen with other types of expertise, not only with DNA. What about the civil procedure? I would like to invite experienced attorney to stage. And one of the defense lawyers has also written about obtaining of evidence and admissibility of evidence. And as experts' opinion is one of the types of evidence, then the defense lawyers are likely to mention their work as well. So our speakers now will be Mr. Lauris Rasnač and Mr. Mārcis Krūmiņš, lawyers from Latvia, and they will speak about expert opinion as one of the evidences in civil procedure and its assessment. Welcome, gentlemen.
Labdien!
Good morning. Thank you for this opportunity to speak at this conference, and it is an exclusive and rare opportunity for me. As a lecturer in the university, I find it much easier to speak after somebody else, some other speaker, as then I can know how to edit my speech. As a lawyer, I'm used to speaking after a prosecutor, but to speak after the judge, this is a rare chance indeed. And if we look at my presentation, then I will speak about one of the means of providing evidence. In Latvia, I will refer to this sentence, the judgment, and this confirms what Prosecutor General already said, whether expertise is always necessary. In the civil proceedings, sometimes there was a practice that if the judge considers that expertise is necessary, he could appoint it or ask for it. Presently, our law provides that if the case is reviewed in appeals court and the appeals judges point out to the parties that experts' this opinion would be necessary, and when the case is further forwarded to the Supreme Court, and in the Supreme Court the reviewing is cancelled because of lack of expertise, and this is absurd. As our colleagues, Mr. Prosecutor General particularly, said that we want to achieve a fair sentence. This is why we go to court, and the court must be given this opportunity. No, yes, of course, there is this principle of competition. But besides the principle of competition, in the civil proceedings, there is economy principle that must be respected, not only in terms of time, but also in terms of costs. Our judges are sufficiently qualified to assess whether expertise is necessary. If a judge sees that there are grounds, sufficient grounds, for the ruling without the expertise, and expertise is not necessary. It is no secret that our existent practice is such that the judges specialize to some extent. It is not that all the judges hear all the cases, and perhaps I would like to refer now to a ruling of the Senate. And in the criminal law, it has been done by the 1st of September. And why are we afraid to adopt the same decision in the civil proceedings? When a judge starts reviewing a case, he studies the case. And why couldn't we trust the court and the judge with this decision of whether expertise is needed? Perhaps I'm taking too much time, and I would like to now focus on failing to comply with the procedural order. Presently, in cases when the judge asks for an expertise and justifies the need for it, then the expertise will be provided. With regard to the ruling in question, which is referred to here, it is a ruling of 2007, but lately I have not met with any case when courts would deny expertise. To the contrary, it is permitted, the expertise is assigned, and then the question that is more relevant is whether it is always necessary. It is worthwhile thinking about that. And the other aspect of the issue is this part which concerns the opinion. Of course, it means that the issue has been assessed, but my internal conviction, which has been there for more than 10 years, if the court assigns an expertise and the expert gives an affirmative answer and one of the parties does not agree with it, then they can ask for an additional expertise, and the rule permits it. But what is the justification in cases when the expert who undertakes the responsibility provided by the criminal law to try to dispute the expert's opinion, if it is justified and is affirmative? If a person is considered to be an expert, we trust him, the state trusts him. he is responsible. He carries the maximum responsibility. Why not trust him and try to repeat the expertise somewhere else? Yes, possibly the judges do not agree with the opinion, but then it is unjustified in this case. I have to be in a court hearing outside Riga in the afternoon, and I will not be present during the entire conference, but I do hope that our colleagues from other countries will express their opinion about this issue, how they see it. The judge has to assess all the evidence with the power of evidence that they have, but there will be another speaker, my colleague, who will speak about evidence. Lauris Rasnach. Good morning, ladies and gentlemen, colleagues. Thank you to the organizers. Thank you to Marcis for this part of the presentation, which stopped at a comma, or rather put a comma in an important issue. Namely, what are the relations of experts' opinion with other means of evidence in the case? I would like to differ from my colleague on the issue of how experts' opinions are comparable to other evidence existent in the case. In my opinion, experts have to be assigned according to a specific procedure. They have special requirements as well as criminal liability and other recommendations and regulations. However, it must be taken into consideration that rarely in any discipline of science there is a unanimous opinion existent on one specific issue. And therefore, regardless of all the regulations and criminal liability, there may be situations, and in my opinion, it is not unnatural at all, that various specialists may have various opinions on the same issue. So the question is how to assess it all, how to put it together to arrive at maximally fair and justified ruling. And in practice, we often see that the expert's opinion as evidence or means of evidence often compete with other evidence existent in the case, particularly with two forms of other evidence. The first is the conclusion of a specialist, which can be classified as one of the written evidences from the point of view of civil procedure. It must be taken into account that this evidence is provided and submitted by the parties. There is no special procedure, no special liability, and therefore the question which has to be assessed by the professional is decided by the party who prepares this evidence and submits it. But the question then is that is this the reason why this written statement, written opinion of the specialist has lesser power as evidence than experts' opinion? We cannot give a categorical answer to this, in my opinion, as this position would be incompliant with the principle of impartial assessment of evidence, and particularly on issues where experts have to be selected from the circles of other persons with specialist knowledge, but not from the list of court experts, then occasionally these specialists are assigned as experts on the particular case, But in some other cases, they prepare a written statement of a specialist on the issue. And can we assert that his opinion has lesser credibility just because he is not formally assigned as expert? Then the question is how to assess this.
It's a matter of qualifications. It applies to the expert, to the specialist. What is the qualification? As Mr. Stokans has already mentioned, if the expert has been included in the official register, then their qualifications can be easily confirmed because they need to comply with the requirements of the register. But still, we need to evaluate what is the qualification of a potential expert who is not yet included in the register. And in some cases, we see that there is a discrepancy between the conclusions made by the forensic expert and another expert. And here I might be opposing Mr. Stokans because, in my opinion, the court cannot do otherwise, at least in civil process. They cannot verify the education of the expert and the knowledge in any other way than the one that we have right now. Because requiring an official exam in their profession, that might be too harsh. And in my opinion, there are ways to make such checks essential and necessary. We know that there are some very formal cases, but there are ways to ask pertinent questions to determine whether the person is qualified so that all parties are satisfied. And if a party considers that the knowledge does not match up to the requirements, there is a possibility to indicate this to the court. Likewise, when we consider these two types of evidence, the forensic expert opinion and the specialist opinion, we need to see whether there is an overlap for the issues involved. We know that the court finally decides what are the questions to be asked to the forensic expert, but the parties decide what are the questions to be asked to the specialist. And in some cases, we see that the questions are not identical, and we need to assess to what extent these questions overlap and whether there are mutually exclusive answers coming from both sources. Another thing that I consider to be the most important is the matter of the argumentation and the motives of all evidence points. Of course, we cannot require the court to examine all matters to consider whether the mathematical and physical calculations of the expert are correct, and so that the court would go over all the formulas. But the court needs to see whether the argumentation is complete, whether it is satisfactory, and they need to provide the opportunity to the parties to speak up on the matter and to indicate whether they see some flaws. And finally, as regards the assessment of evidence, there's a thing that I think should be used more widely than it is now. When we are inviting forensic experts and when we are interrogating specialists, when we are assessing their reasoning and the basis for their conclusions, the expert and the specialist, they need to explain how they arrived at their conclusions. Another tool which can sometimes compete with the opinion of the forensic expert is an institutional opinion. And I don't want to generalize, but I think that institutional opinions are very rarely used in the civil process in Latvia. I don't see an issue with this really, because well, there are reasons for that. But there are two things that I consider to be topical in this context. One, when we are going over the evidence and the tools, and when we indicate to the parties in accordance with the civil procedure law that there are no items of evidence submitted pertaining to the matter, there might be a case when, according to the procedure, you invite the parties to explain their position, and you need to clarify whether you need an opinion of a forensic expert or you need an institutional opinion. So there might come a point in the process where you need to decide this. We had a case when, if I remember correctly, the opinion was provided by the State Patent Service, but from the procedural point, it was not clear whether this is the official opinion of the institution or of the employees of the Patent Service. So whether the employees spoke as specialists or whether the institution spoke as a whole. And you need to have clarity. Another thing I would like to mention in this context: in most cases, I think you need to make sure that the forensic expert opinion prevails over the institutional opinion. Seeing as the time is snapping at our heels, I would just like to mention one last point. How detailed should the forensic expert opinion be? And in general, I would like to say that, in my opinion, it should be as detailed as possible. We should not support the practice that we see sometimes. It has unfortunately penetrated the Latvian judicial system through the American practice, where the forensic expert just gives a summary, just gives a very brief statement, and then there are questions about this executive summary if you need to clarify something. I don't support this practice in the Latvian civil process, not at all. Absolutely not. And this is not something that we should be taking over from our American colleagues. And this is something that I would like to point out. And this is the key takeaway message I would like to make in the end of my presentation. I believe that the forensic expert opinion needs to be as complete as possible so that all the parties are capable of understanding the facts of the matter on their own or with additional help. And if there are some things to be added, they would be inviting the forensic expert to prepare additional clarifications. It needs to be as complete as possible. With this, I would like to conclude my presentation and thank you for your attention. Unfortunately, I will not have the opportunity to continue participating in the conference, but despite that, I wish you a very fruitful day and very informative discussions. In case you have any questions about the topics that we have touched upon, we'll be happy to receive your emails. Thank you for your attention and have a nice day. Thank you. We are very sorry that attorneys at law are not able to stay for the panel discussion, because I'm sure that we would have riveting discussions about what the forensic expert needs to say, how much they need to say, and why specialist opinions are more debatable than forensic expert opinions. So we're sorry to see you go. We're sure that our foreign guests will also touch upon similar matters, and will be able to see what the common practices in their countries of origin, what are the preferred methods for forensic expertise, because we see that attorneys at law might consider the methodology of Latvian forensic experts superficial if they don't find the statements sufficient. Well, we'll see. But we thank all the attorneys at law for their presentation. And since we've had an insight from the attorneys in the civil process, we would like to have another opinion, and we invite Madam Gunta Ozoliņa, who is a judge of the Riga District Court and member of the Civil Matters Collegium. And she's going to speak on the just sentences as guaranteed by the analysis provided by a contemporary thinking forensic expert. Ladies and gentlemen, dear colleagues, I'm very glad to be able to meet you on this wonderful day, and I thank you for the opportunity to present my vision of some specific matters pertaining to forensic expert opinions as tools for ensuring justice in civil matters. I would like to begin by saying that attorneys at law have already touched upon many things I wanted to mention. So I will try not to repeat myself, but in case some things do come up twice, don't be too harsh on me. I apologize for speaking too quietly. Now I will speak closer to the microphone and you will hear me better. Now I'm going to start so that we are on track to reach coffee break as planned.
Differently from the previous speakers, I would like to use some figures in my presentation. I thought this is important to give you an insight about the current situation in the courts concerning the means of evidence. In the modern society, there is a diversity of civil relations, and they have a tendency to become more complex. Today, in the 21st century, in the era of evolvement of technologies, in order to provide justified and grounded sentences, we use special knowledge in science, technologies, and art. Experts' opinion, a document which has to be in compliance with the requirements provided by Section 124 of the civil law. The civil law provides for the written form of expert statement. Expert's opinion is regulated by Sections 124, 125 of the civil law. The court has to do its utmost to find out the circumstances in the case as fully as possible. And preconditions of fair ruling are legality and justification of all the decisions made. And looking in the system of courts today, we see the following situation. The Riga Regional Court, Appeals Court, has assigned 7 expertises in 2018. This is the first half of 2018, from the 1st of January till the 30th of June. It has assigned 4 expertises. For comparison, the regional courts of Kurzeme and Latgale have not assigned any expertises. Vidzeme Regional Court has assigned 1 expertise, but Zemgale Regional Court has assigned 2 expertises respectively. Initially, it may seem that obtaining of experts' opinions is not popular due to the low figures in the statistics. Yet it must be taken into account that obtaining of new evidence in the appeals court have to be justified, namely why this evidence was not submitted in the first instance court. And I would like to quote the section of the law which says that the court has to explain the need of evidence if it is really necessary, and the appeals court must justify the necessity to ask for experts' opinion. At the same time, the first instance court has the utmost responsibility, which has to make this decision and to ask for expertise in the first instance hearing. And the appeals court can take over this task and ask for additional or supplementary evidence or expertise, but then it has to provide a very thorough justification of that. So the main work with evidence is carried out in the first instance. And therefore, the frequency of assigning expertise or experts' opinions can be best assessed by looking at the expertise used in the first instance courts. And in the period of the first half of 2018, the first instance courts have asked for 181 experts' opinions. Riga District Court has asked for 97. Riga City Vidzeme District Court 28. Riga City Pārdaugava Court 26. Riga City Latgale District Court 27, and Riga Regional Court 27. In Kurzeme Court region, 23 opinions have been provided. In Latgale region, 29. In Rēzekne District Court 9. In Daugavpils District Court 20. In Zemgale Regional Court, 22 experts' opinions have been provided. This glimpse into statistics, however, can be a bit misleading, as it is a very specific case when this kind of evidence is needed. It depends on when this application has been made to the court. It may have been declined, and there are the so-called specialists' opinions used as well, but I wanted to give you an insight of what the general scene is like, how we make decisions about obtaining experts' opinions presently. And the statistics in the court system provide us with this opportunity to do this in a fast, a contemporary way, and to also to express it in the form of figures. Doubtlessly, parties in the case have desired to use this form of evidence. The court has ruled that this kind of evidence is necessary. The expert has provided an opinion. The opinion, according to Section 97 of the Civil Procedure Law, is assessed in the verdict, and the result is a fair ruling in the civil case. And for clarifying the circumstances, expert's opinion has been used. In the civil procedure, parties often justify their claim with documents. Sometimes we call them specialist opinion or expert's opinion. And to fully implement the competition principle applied in the civil cases, the courts must inform both parties about the possibility of using private experts' opinion in case if one of the parties disputes the expert's opinion. The court has a particular section in the law to clarify and explain the situation. In this case, the competition principle is implemented by giving both parties equal rights to ask the experts for opinion, which would help to clarify the true conditions in the case and thus foster making a fair ruling. I must agree with one of the previous speakers, lawyer Krumins, who said that it would be important for the court to see where the specialized knowledge is necessary, and the court must have the right to decide about assigning expertise or asking for expertise, particularly in cases when we deal with incompetent parties in the case, at the same time, they do not have the status required for obtaining defense lawyer paid by the state, and such situations may occur. And experts' opinion can be of high quality only if the correct question is asked to the expert so that he can give the answer according to his competence. And there is a number of preconditions which enables the expert to provide a quality opinion. And one of these preconditions is the ability to ask precise questions to the expert in the form that would allow him to give unanimously understood answers which would help the court in its work. To relieve the court's work and to promote the effectiveness of using experts' opinion in its work. In the civil procedure law, it would be useful to provide a methodological aid which would cover the areas where the experts most often provide their opinions and would provide sample questions for the courts to show how to formulate the questions to the expert in order to achieve a result in the form of high-quality evidence. This is a wish for the organizers of our conference to think about the cooperation with the court to elaborate such methodological materials. As preparing for this conference, I reviewed 40 rulings and sentences about assigning expertise, and asking of questions is a painful area for the courts. And experts' answers very often are overlapping, or rather wider than the actual questions asked. The experts try to think about legal issues, forgetting that they are asked to give only their specialist opinion and nothing else. In order to improve the effectiveness of the procedure, it would be important to provide the possibility for the expert to submit their opinion electronically with electronic signature as soon as it is prepared. Video conferencing as a tool would also be useful, allowing the expert to confirm the truthfulness of his opinion and for answering the questions asked by the court. But the expert, at the same time, should also be given the opportunity to provide an electronic signature complying or proving the compliance with the rules demanded by the court or in their work about the undisclosure of the information, truthfulness of opinion, and the like. Even though the present regulations in Latvia do not provide for it, it has been assumed practice in the past, and it could be continued in the present as well, in view of the opinions voiced by the experts. In view of the rapid progress in the development of artificial intelligence, separate areas of expertise could adapt to the new technologies, and programs or software will be able to provide expertise in certain areas. Therefore, experts and legislators in cooperation should provide for the respective regulations to make the practice effective in the future. Thank you. Thank you, Mrs. Ozoliņa, for a very laconic summary of conclusions on the topic. In your presentation, I heard something that I would like to object to without waiting for the panel discussion, as the time permits to do this now. In view of your criticism of the questions formulated by the courts to the experts, I have a very good recipe. We should reintroduce the relevant course in the law faculty, as criminalistics presently is an elective course, just like folk dancing. Then it is not surprising that it will be difficult for the court professionals to formulate questions, because we must learn to do this professionally. It is regrettable that we have not invited any university professors who could hear all this, but I have used all the opportunities to talk to the university faculty about this problem. As to the verbal or oral opinion of the expert, yes and no, because as the expert is preparing his opinion, he must carry out research, and this may delay the court hearing, court procedure, and problems may arise, particularly in the area of psychiatry. Technically, this may also be difficult to solve. This is a very good proposal. It might relieve the work of experts and courts in some situations, but since we live in the 21st century, we use a lot of technologies, and an expert still is not able to arrive in the courtroom with all his equipment, like a mobile lab. But the civil procedure is the kind of procedure which has stipulated the least number of criteria with regard to expertise. We can only dispute an expertise if we have two experts' opinions which contradict each other. And what will the third expert's opinion give us in that situation? There are situations when an expert says it is possible, the other expert says, well, it may not be possible, and the third expert says, I can't say. And then the court thinks, well, maybe we should ask the fourth expert, and that will help us. Or yeah, this is an option, but it is a very expensive option.
But now we are ready to restart our discussions. After our coffee break, I would like to tackle a very serious issue. Forensic expert opinion. And please don't take offense. I don't mean that all other procedures in the legal proceedings are unimportant and it's just the forensic expert opinion that matters. No. But we know that the opinion of a forensic expert is something that frequently ignites a lot of discussions. It has to be justified, it has to be well considered, and it is also frequently open for interpretation, and people ask themselves how they're going to interpret it. So I'd like to invite my colleague from Scotland, Jonathan Morris, who has been working as a forensic expert for documents and for handwriting for many, many years, to take the floor. We know Jonathan as a person who thoroughly supports quality systems and their implementation at court. He has taken on this challenge with great enthusiasm, and he has been developing good practice handbooks and different guidelines for forensic experts. Jonathan has really taken to heart the matter of ensuring suitable qualifications for forensic experts and the verification thereof. Jonathan has developed a lot of tests that enable a forensic expert to verify on their own what is their level of professional competence. Have they grown or have they regressed? But I don't want to talk too much about Jonathan. I would like to hear him talk for himself. And I'm going to introduce his presentation in Latvian. We know that the Latvian translation is incomplete due to lack of vocabulary. But he's going to talk about logical reasoning and evaluative reporting. We don't have exact terms in Latvian, but we understand what it means.
I didn't have my headphones on, so I didn't understand a word. Apparently, I'm going to be talking about this. First of all, thank you very much for inviting me here to speak on something which has growing importance within forensic science across Europe in general, and that's how we report our casework. The purpose of this short talk is to present the process of logical reasoning and evaluative reporting in forensic science. Over the past 25 years or so, there has been a paradigm shift away from traditional reporting into a new evaluative reporting process. What I'm going to do is just go through a couple of definitions at the beginning of the presentation, to talk a little bit about the different reporting styles that we have for forensic science in Europe, to talk a bit about the evaluative reporting process. This may be new to some of you, it may be absolutely brand new to a lot of you. And I'm going to finish with a worked example of casework. Now, I'm a handwriting expert, so the example that I will be using at the end of this is a handwriting comparison process, but it is still the same principles across many of the other forensic disciplines that we deal with. First of all, the Oxford English definition of an opinion. As forensic scientists, we always give opinions, and this is the Oxford University definition. It's a view or judgment formed about something not necessarily based on fact or knowledge. Now, I've stood up in court and given an opinion, and then I've been challenged by that, saying, well, an opinion is just your belief, not necessarily based on science. Whereas a conclusion is a judgment or decision reached by reasoning, and a scientific conclusion, therefore, is a judgment or decision reached by scientific reasoning. I'm going to use two other terms for the forensic reporting or forensic casework that we deal with. Much of the forensic science that comes out of a forensic science laboratory is based on objective assessments of the work. An objective is not being influenced by personal feelings or opinions in considering and representing facts. And this would be an example of this drug is cannabis, this shoe did not make this footwear mark. These are objective statements based on fact. Majority of forensic science is subjective. It's based on or influenced by personal feelings or opinions, and it is basically an assessment of the strength of scientific findings. Much of forensic science, and particularly handwriting, tool marks, footwear, and others, are based on subjective findings. So what's the current status? Well, we have a large number of documents produced about how we report. There's a German, the American SWEG documents, the modular approach produced in Australia, the EMSFI. Quick show of hands, how many people have heard of EMSFI? Okay. EMSFI is the European Network of Forensic Science Institutes, of which the director of your laboratory is one of 63 different laboratories across Europe, principally government laboratories, but also including universities, who formed this group, this body, to help try and improve forensic science across Europe. And EMSFI have produced a guideline on evaluative reporting, as have the Australian group, the National Institute of Forensic Sciences in Australia. In 2015, the EMSFI guideline was produced, and 2017, the NIST guideline, and the other papers here are just examples, and just a few examples of documents that have been published talking about evaluative reporting of forensic science. And it is growing. As you can see, the speed of these documents is increasing. So actually, how do we currently approach subjective forensic science? Well, we do it in what's called a two-stage approach. First of all, at stage one, the scientist tends to identify points of difference between two things and eliminate that person from writing this document or that shoe from making this mark. That's the easy bit, because that's a spot the difference. And anyone who's done spot the difference competitions, that's the easy part. The difficult part comes on a two-stage approach in identifying the points of similarity and apportioning strength to those similarities. And that's really where, as scientists, we can just be picking a strength out of the sky based on our experience and our knowledge, but not necessarily based on any consistent rationale between the disciplines. This approach is currently enshrined in most laboratories. It's a terminology guide. It's structured like an ordinal scale, so basically a scale that has sequential and equal steps. And it addresses, amongst other things, probability and uncertainty. But there has been no validation of that process in its reliability in reporting forensic casework. And certainly the approach to it across European laboratories is very different between laboratories. So Ian Evert, who is proposes the use of evaluative reporting, wrote in the Journal of Forensic Sciences, if forensic science is scientific, it has to be logical, and if it is logic, it follows that probability to be invoked. So if we're going to use probability in our approach, then the laws of probability cannot be violated. What he's basically saying by that is that we're science, we're scientific, and we need to be scientifically logical in our approach to how we report casework. So what we do may or may not be scientific, but at least we should try and be logical in our approach to reporting casework. And the terms like probability or strong probability or whatever have tended to be misdirected, meaningless in some cases, and irrelevant. And I don't think that very many forensic scientists actually understand what they mean by it, probably or highly probable, because it means different things to different people in different countries. So what do we do about it? It's been mentioned this morning that forensic scientists are part of the decision-making process. The courts call forensic scientists in to give the evidence that that forensic scientist is going to be presenting. We are part of the decision-making process. We are not the decision-maker. We are not the ones that actually tell you whether or not someone is guilty or innocent. That is for the courts to decide. We are only part of that decision-making process. And as forensic scientists, we assist by explaining the evidence that falls within our domain. So within handwriting expertise, I can report on that, but I wouldn't report on other areas. And it also needs to relate to the matter at hand for the court to determine what it is that they want us to be presenting. We need to answer any questions and consider other possibilities that the court may throw to us. Because when a trial starts, and we are in the dark when a trial starts as to what our evidence actually means to the outcome, things will move. Trials are a moving feast, and it may well be that when it comes to the forensic expert, different scenarios have occurred that we weren't aware of in the first place. So we need to be aware of changes to possibilities that could affect the strength of our scientific findings. And we should do this using science and not picking evidence out of the sky. Science implies using both logic and reasoning and, ideally, data. Now, I'm not going to talk about data too much because in forensic handwriting evidence, we don't really have any. And in other areas of forensic science, we don't really have the data that will support the conclusions that we may be giving. But within EMSI and within the EU, we are beginning to develop databases that we can then use to start to give numerical values to some of our findings. We need to explain the reasoning and also include limitations within a framework that we are working within. So it's the first time I've mentioned the framework. So in the role of logical reasoning in forensic science, there is a framework, and there are three basic rules that we as forensic scientists need to follow. Framework of information. This is the context information that we are given as scientists that we can use to help support the findings that we have given. The idea of context information and context information management is one that would be the subject of at least a 2, if not 3-day conference, because it's a very complex process. But we are sometimes told that we have CCTV footage of the person walking into the crime scene wearing a particular type of shoe. We have CCTV footage of the person going into the bank and signing their signature. Some of this information is relevant to our science, some of it is relevant to the courts, and we need to manage that context information, but it's not the purpose of this presentation this morning. We need to consider at least 2 competing propositions. Now, in the old 2-stage approach, we were normally asked, did this person write that document? Did this shoe make that mark? And we tend to only answer that question. But in reality, the question is, did this shoe make that mark? Or was this mark made by another shoe of a different, from a different manufacturer? Or the same type of shoe, but a different shoe? And we need to consider those 2 competing propositions and evaluate our findings in light of those propositions. And we need to consider the probability of the evidence, not whether we think something happened, but it's the probability of the scientific evidence occurring. So this is our observations. Colin Aitken, who's a professor at the University of Edinburgh, he's a statistician. Some of you may have heard of the likelihood ratio. I heard of it first time about 20 years ago, and it's only taken me until 2 years ago to actually understand what it means. So you're not going to understand it this morning. But the likelihood ratio is a measure of the value of evidence in terms of 2 probabilities conditioned on different assumptions or propositions. And these 2 likelihoods or probabilities then represent, and this is important, the likelihood of the evidence, i.e. our findings, if the prosecution's proposition is true, that's one of the propositions, and the likelihood of the evidence if the defense proposition is true, that is the other proposition. So there are your 2 propositions, and we are evaluating the science in light of those. And the relative values of these 2 likelihoods provides a measure of the meaning and probative value of the evidence. So from these slides here, as scientists, we need to be considering the value of our scientific findings in relation to 2 conflicting or competing or opposing propositions. That's the only equation I'm going to show this morning, because I don't like equations. The only bit we need to be interested in is over here. This is the Reverend Thomas Bayes, who thought up Bayes' theory back in the 18th century. The prior odds is really the information for the court. Where does the court stand prior to the forensic scientist going in? The posterior odds is where the court will stand after the forensic scientist has left the court. That bit here, which is the likelihood ratio, the ratio of the strength of findings for one proposition over to the other proposition is the realm of the expert that you'll be calling to court. So this is the likelihood ratio. Before I go on, I just want to say, and it was been mentioned this morning, about the problem with absolutes. This is the Madrid train bombing. I can't remember the year, but as a result of the train bombing, a finger mark was identified. That finger mark was sent to the FBI laboratory in America. It's America again, but sent to the FBI laboratory in America. They had samples of a fingerprint, and they said that this finger mark here comes from, definitely, conclusively, the same person that provided that finger mark. And that was a gentleman called Brandon Mayfield, who was an Oregon state lawyer who had never been to Spain, was actually in Oregon at the time that the bomb was put on the plane, but the FBI said that it was definitely his fingerprint. Conclusive. They then do a bit more digging when Brandon Mayfield sort of says it couldn't possibly have been me. They go through some more work and they identify the finger mark of a guy called Dawood, who was an Arabic guy whose fingerprint matched. And the only conclusion the FBI could say was that Brandon Mayfield's fingerprint matched conclusively, but Dawood's was a better match. Now, in terms of forensic science, that makes the forensic scientists look absolutely ridiculous because they've given you a certainty and then they've got a better certainty. I don't quite like that. If it's horse racing, I could have coped with it, but not in forensic science. So that is a problem with giving certainty in terms of conclusions. So what is the evaluative reporting process? And this is documented in the Australian guidelines, and if people need the reference for it, I have it with me. But you start off with your propositions, and they're based on the case circumstances, defense and prosecution scenarios, and the test material. They shouldn't change unless you get new information. The next part is you look at the expectations. This is what you would expect to find before you do the comparison. So you would look at the questioned item, and you'd examine the question item and say, what is it in here that I would expect to find in the known samples if they have come from the same source? So there's an expectation. These are the features that you're looking for, the significant points of comparison that you want to get. You then get the analysis part, which is the standard forensic comparison. You get the findings as a result of that analysis. Then you get the evaluative part of it. And the evaluative part is a consideration of all of the observations that you have made in this phase, in light of the propositions that you have at the start, the expectations you have, and relevant information, limitations, knowledge and experience of the scientist. And it's in a non-numerical process in most cases, because as I say, we don't have the data to be able to back some of these up. And then we report the results in the form of a forensic report, which will include the information used to form the propositions, available test items. And again, earlier this morning, we talked about the forensic science report should be inclusive, including of as much information as necessary, and I would wholeheartedly agree with that. I think a summary, as a single summary report, is of little value to the courts whatsoever. You need to be informed of the reasons why we have come to a particular conclusion. So here's the worked example, a question signature and 8 samples. So what are my propositions? Now, in conjunction with the prosecutor, maybe with the court, we will come up with these propositions that we are going to be challenging. It may well be that the prosecutor will already have an understanding of where the defence might be coming from in a particular case. So we will look at the propositions and generate those, and we will work from those in their entirety unless we get new information. We look for the expectations, and we go through the process. As I say, we've done propositions. I think we're going to have to skip through some of these anyway. But here are the propositions in this case. Proposition H1, the question signature, is written by the supplier of the known signatures. So the alternative proposition is that the question signature is written by another person. And you can see how this will work for other areas of forensic science. This footwear mark was made by this shoe. This footwear mark was made by another shoe. These hair fibers came from this particular jumper, these fibers came from this particular jumper. These fibers came from another jumper. And we'll hear a bit more about that later. But you can see how it works for the forensic sciences. We then have the expectations, which has died. Okay. What would we expect to find if H1 is true, and this is the same writer? Well, we'd expect to find they would look pictorially similar. You may find many similarities in the fine detail between them. You will find fluency similar in the same parts. And for handwriting experts, they'll understand where I'm coming from. But again, this is what we'd expect to find if H1 is true. If H2 is true, we would still expect it to find a pictorial similarity between them, but we may find a number of differences in the fine detail, differences in the level of fluency, hesitations and pen lists. So these would be what I would expect to find for those two propositions. And these are the points of similarity I'd expect to find, and this is just areas of fluency. So these are the features I would expect to find in my known samples. So what do we get from the analysis and the findings aspect? We find quite a lot of similarity, the blue marks. A difference, maybe some features that we think are okay, but we find quite a lot of features that are similar and some that are different. We also consider, as part of the analysis and the findings, limited known samples. We only have 8. Relatively simple in design, so relatively easy for someone to copy. It's stylized, you can't tell the person's name from that signature. So these are all considerations that we need to make when we come to do our evaluation. And the way that you evaluate it can be thought of in silos, and you add your scientific findings to one or other of these. So, for example, we have something that might support the defense hypothesis. So your defense hypothesis silo increases. Your likelihood ratio has an increase of scientific findings for proposition H2, which is the denominator here. So you have a small number over a bigger number. If that case were to stop at that point, the scientific findings would be pointing towards H2. As the examination goes on, you start to add findings into H1 and H2, so the equation, the ratio changes slightly. And as a complete summation of all of the scientific findings, you suddenly find that the probability of the evidence given H1 is much bigger than the probability of the evidence given H2. And it's just a very simple way of presenting what we are doing in terms of an evaluative process. When it comes to working out the final evaluation, we need to put a term or strength against the scientific findings, and one that I've used is you have extremely low support for a proposition through to extremely high support for a proposition. And remember, this is just for one proposition. And you then give each of the two propositions one of those values. So in this particular instance, I said the probability of the findings for H1, that it's the same writer, is high. Remember that I had a big number on the top of my equation. The probability of our findings for H2, I deemed it to be low. That's my evaluation. When you come to the likelihood ratio, you have a high over low, and this is where my maths is quite good because I can do this bit. A big number divided by a small number gives you something that's much greater than 1. So anything that is greater than 1 supports proposition H1. Anything that is less than 1 supports proposition H2. And the likelihood ratio depends on the complexity of the signature and the other findings from the detailed comparison. So how do we report this? I think we need a new... So given that our findings show that the ratio is high over low, which is greater than 1, in my opinion, and based on the scale that we use, This indicates that the findings provide strong support for the proposition that the question signature is genuine as opposed to having been written by another person. So the scientific finding there is this strong support. And this is the bit that is a bit alien to a lot of people, because where does strong support fit on a scale? So what you have to provide the people with is the scale. Just to give you a quick example, if my ratio of the scientific findings for H1 and H2 are equally likely, we have a ratio of approximately 1, and we can't really help the court. If the scientific findings for H1 are much greater than H2, and if the scientific findings for H2 are much greater than H1, we can report on these. This is a bit that causes some people some angst, some anxiety. If you have really, really strong support for H2 and no support for H1, i.e. this shoe mark and this shoe have a completely different pattern on the bottom, you can say that they come from a different source. But that then becomes no longer an objective finding, it becomes, a subjective finding, it becomes an objective finding. It's a finding of fact. They are different, full stop. And that's the situation you get here. Why you cannot report conclusions of certainty, definite, is because if all of your findings support H1 and none of your findings support H2, you have a ratio of 1 over 0. 1 over 0 is infinity. It's not certainty. You just keep on going and going and going. So you can't have a conclusion of certainty. And that's why in the Brandon Mayfield case, the fingerprint people should not have been certain, because even at the end of their examination where they thought the ratio was this, they went certainty, where in fact they should have been concluding less than certain. And I'm going to finish by just giving you the example of the scale that my working group, NFEX, and other working groups in EMSFI are using. And I know that this is a sort of scale that is now being used in an increasing number of European forensic laboratories. You have a number of points supporting for H1 over H2, with the strongest being extremely strong support. And you have strength of findings for H2 over H1, again with extremely strong support. What this scale does, which the old scale did not do, the old traditional two-stage approach did not allow for the weak or limited support evidence. We had definite, highly probable, and probable, which were all considered strong conclusions, and this enormous gap in here where we had nothing that we could report. But from the legal systems in the United Kingdom and elsewhere that have been using this scale, forensic scientists can assist the court, and that's what we're there to do. We are there to assist the court in evaluating the strength of all of the findings. By reporting in this area, we've actually increased the number of cases where forensic science and forensic science evidence has proved useful in terms of a court trial. That's the presentation. It's summed up in 20 minutes or so what it took me 20 years to understand. And it's also summed up in 20 minutes what it's taken statisticians and other people that work in this area week-long courses to understand. So if there's any questions, please feel free to find me at lunchtime. I've got to disappear on a flight back to the UK at about 2:15. So if you want to ask anything about this, please find me at lunchtime.
Liels paldies Jonathanam par šo.
Thank you very much, Jonathan, for this very complex and dense presentation. I hope that you will take lunch with us, and all the participants will be able to get Jonathan's contacts to ask their questions before he leaves for his 2 o'clock flight. We have had small changes to our agenda. I would like to invite our next speaker, Madam Birgitta Rasmussen. I apologize for not being able to pronounce your surname. For a Latvian, it's very difficult to pronounce. Birgitta is a forensic expert at the Swedish National Center of Forensic Expertise. She is an assessment and evaluation expert, and she will take over from Jonathan in examining this topic of what it means when an expert says that something is possible or something is probable.
And it's a great honor for me to be here. Unfortunately, I had not the opportunity to listen to your introduction, but I come from the National Forensic Center in Sweden, and my new family name, I got married in August, is Birgitta Rådström. So now you know what the dots are for. We are very fond of dots and little circles in Sweden. I'm going to sort of continue on Jonathan's presentation, and you will recognize quite a lot from his presentation, and I will continue on that. And my issue here is whether Bayesian theory can be applied to the whole legal process. Oh, thank you. So a little bit of where I come from. In Sweden, we have a National Forensic Center, which is part of the Swedish police, but we are quite independent. We have currently 520 employees. We do around 160,000 cases every year in all forensic areas except forensic medicine, so it's also drugs and DNA, but also, for instance, handwriting, shoe marks examination, and all kinds. It's in total between 30 and 40 subject areas. We also do a lot of education and training of crime scene officers, prosecutors, defense lawyers, and judges. And we have worked with evaluative reporting for many years now. Since actually we started in the 1990s, we got some interesting ideas from the UK, who was very early on this, and we applied them to our lab. And since 2004, we use a 9-level scale to report our findings, which is actually very similar to the one that Jonathan showed. I will show you ours in a little while. It's based on exactly the same principles. And we do that for all subject areas except fingerprints, which is kind of special because they have a special culture, which Jonathan referred to. It has its problems. So what we are trying to do in the lab is to get these worlds to come together, and that is one of the tasks that we have taken upon us together with other people internationally. But we also do evaluative reporting of crime scene results, which is unique, I think. In the last years, we have expanded this Bayesian theory thinking into the crime scene because we want to connect the crime scene to the lab. And at the crime scene, we have defined 4 evaluative expressions, which is the sort of value expressions that the crime scene investigators use in their report. This is our 9-level scale, and I won't go through it in detail. It's very similar to Jonathan's. The difference is that we have defined, you see, the traditional explanations here is very similar to Jonathan's, if not exactly the same. It's in words, but we have also defined what these words actually means in terms of magnitudes. Not exact numbers, but magnitudes of the likelihood ratio. So each of these levels here, they correspond to a range of likelihood ratios. For instance, a +3, then the likelihood ratio is somewhere between 6,000 and 1 million. And a +2 then the ratio is between 100 and 6,000. But you can express this either in numbers or in words, and you can also calculate or estimate or assess your likelihood ratio using numbers, but you can also do it using words. So it's really up to you. The important thing is that you can translate this, and this is also provided to the court so the court can understand what we are writing about. So the last one here is the one that we are favoring now. Best way we think currently to explain what we are, the strength of the evidence. And actually, just yesterday I was lecturing to a group of experienced judges in Sweden, and it turned out that they really like this last one. So that makes us feel confident. They say, this is the way you should report it. This is the most understandable way for us in court, if you report it this way, the strength of the evidence, the likelihood ratio. But it's very good that you have this table attached to the statements, because if somebody uses another phrasing, then we can understand what that is also. So we're working towards that. And to expand a bit on what Jonathan said then, what we are dealing with are unique events. Crimes are unique events, which cannot be repeated experimentally. And that means that the forensic evidence that we look at is connected to something which is a unique event. There are many other unique events: accidents, epidemics, floods, soccer game results. And somehow we need to address this also in terms of probability. What is the probability of a certain team winning a soccer game, for instance? Or a probability that there will be a flooding? That is very, very important for society. And Bayesian theory and methods, which is really a mathematical statistical theory, which deals a lot also with logical reasoning. It helps us to correctly address and assess probability, probabilities in connection with unique events. And it helps us make decisions, as Jonathan said. And actually, it's extraordinarily well suited for the legal process. And not only for what we are doing in the lab, but for the entire legal process. And that is sort of a seed that I want to plant in this audience today, and see what you make of it in the future. So we can look on this in the context of the legal system. We look on this probability. We can look at this probability in different levels, or there are probabilities at different levels. There is the crime level, and for instance, that could be the probability that a certain suspect committed a break-in and entry in a villa. That is something that is a consideration for the court, for the prosecution, and also for the defense, but ultimately for the court. There is also the activity level, which deals with the activities on the scene. For instance, the probability that the perpetrator entered through the kitchen window. That is something that is a very interesting probability for the investigator and also for the crime scene people. And finally, there is the source level, the probability that the suspect's right shoe made the print on the kitchen floor in connection with this crime. And here is where we mostly work in the laboratory, but sometimes we also work on activity level. And you will see an example of this, I think, this afternoon when we talk on fibers, because on fibers the activities, when we discuss fibers, the activities are very important. So we actually work on both these levels depending on the question that is put to us. But mostly we are on source level, but we strive to work more and more on activity level also in the lab. So there is like a hierarchy here, from the little things, the traces and the marks, and how they are connected to different things, found at the scene or in connection with the scene, through to the activities on the scene and up to the crime level. You can also illustrate it with a triangle. The court is in the upper end of the triangle here. And on all these levels, there are hypotheses. Jonathan talked about this source level hypothesis. I called the H1 and the H2 the main and alternative hypothesis, but that's the same thing. These are activity level hypotheses. Here we talk about how the perpetrator entered the house. Either the perpetrator entered through the kitchen window, that is the main hypothesis, based on what the investigator and the crime scene investigators believe, most believe most. That's sort of the main proposition, given what they see at the scene. But of course, the perpetrator may have entered the house by another route, and that is the alternative hypothesis in this case. So that is activity level. And at crime level, we are only interested in guilt, and that is not so little, or of course, that's a big issue, whether the suspect is guilty of the break-in or whether he or she is not guilty. And as I said, the laboratory mostly works on source level, but also on activity level. Crime scene investigators are mostly active on the activity level, and the parties in the courtroom and ultimately the judge is the one who is interested in the propositions at crime level. So we get back to the shoe print. For me, everything starts at the crime scene. And for the last 2 years, I've been working a lot together with crime scene officers, implementing Bayesian thinking, Bayesian methods at the crime scene. And luckily for us, we have since 20 years been responsible for the training of all crime scene officers in Sweden. So they are with us for a year, and we also have a lot of experienced crime scene investigator teachers on our team. And this has been very important for this work that we have done and are doing. I won't talk, because time doesn't permit it, I will not talk in detail on how this works on the crime scene. But as I said, on the crime scene, the work is conducted mainly on activity level, and it is the task of the crime scene officers to propose propositions on activity level and also to test them given the evidence on the scene, and they can also add on evidence from the laboratory. But it is the crime scene officers together with the investigator, and the investigator in Sweden can either be a police officer that leads the investigation or a prosecutor. Together they decide on which materials that is going to be sent to the lab, and also which questions and which hypothesis that should accompany this material. So in this case, they have a main proposition that the perpetrator entered through the kitchen window, and they also have a proposition on the source level that the prints they find on the kitchen floor, that they originate from the suspect's shoes. In this case, a particular print originates from the suspect's right shoe. They secure the print. They also have a shoe from the suspect, and they sent it to us at the lab, and they want a shoe print examination. And there is also this question, of course, was the print, this particular print S001 made by the shoe G-node 001? And in this case, the lab will work at source level. We'll do a comparative analysis, as Jonathan said. We will get results, and we will try to address the question, how probable are these results if the main hypothesis is true in relation to if the alternative is true? And the response then can be as we saw before, that the results are at least 100 times more probable if the mark was made by the suspect shoe compared to another shoe. And this is a level +2. This then is all of this work at the crime scene and at the lab is summarized in reports that is continued in the process to court, which then uses this together with all other evidence in the final process of evidence evaluation on crime level to reach a verdict. So it all comes together, and actually it can all be explained in using Bayesian theory. And I will try to do that finally here in some slides, very briefly. Jonathan used these very nice cylinders to show what this is. I will use arrows, because I will only look at the result, the likelihood ratio. And I will expand what Jonathan said a little bit to the rest of the crimes, the rest of the legal procedure. Because when the investigator and the CSI send something to us, they have an initial belief. They have a belief already on which of these hypotheses they believe the most in. And of course, they send this shoe and this print together to us because they do believe a little more than 50% that this shoe is actually the shoe that made the print. Otherwise, they wouldn't have sent it to us. Maybe they do it sometimes just to exclude, but usually they send in material to us because they have an idea that these things might be connected. So the blue dot here, that is the initial belief, or what Reverend Bayes would, and his successors would call the prior odds. So they are somewhere on the scale here. They are a little towards the main hypothesis. And what we provide is the likelihood ratio. And the magnitude of the likelihood ratio can be illustrated as the slope or the angle of this arrow. So if we provide them with the +2 here, likelihood ratio larger than 100, that means that when the investigators and the CSIs get these results, they can update their belief on which hypothesis is true a little bit upwards. If this would be a -2, so our results would point towards the fact that the alternative hypothesis would be the one that is true, then the arrow would point with the exact same angle, but downwards. You see what I mean? So now they believe, after getting our results, they believe a little more that this shoe was actually involved in making this print. There is no certainty, as Jonathan said. There is actually very little certainty in the legal chain. Nobody knows exactly what happened when the crime was committed. Maybe not even the person that committed the crime. And that is the reality for all of us. We take this further. Now we take this to the prosecutor. What does the prosecutor do? Well, the prosecutor has to consider the evidential strength, which is actually the likelihood ratio, or the combined likelihood ratio of all evidence in the case. That's what you do when you're a prosecutor. And you have to decide whether this all together is strong enough to make a decision, and that is to prosecute. So there is a cutoff here in your updated belief. If this red dot here is above that cutoff, then you feel that I have enough to prosecute. And I hope every prosecutor here agrees with this. I've tried to summarize your work in one slide. And I've also tried to summarize all the judges' work in one slide. Now we move into the courtroom. And the court, the judge, is only interested in whether this particular person who stands in front of me is guilty of the particular crime that he or she is accused of. That's it. It's not such a small issue, but that is the question. So the hypothesis here is Bob Smith is guilty. That is the main hypothesis. The alternative, Bob Smith is not guilty. And here, Bob Smith is in court. He has been prosecuted for this crime. That means there is quite a lot of things that sort of speak against him. So that's the red dot here. That's the same level as that's the level for the prosecution. That's the sort of the level that the prosecution brings into the courtroom. But the judge here, he has to force himself to presume that Bob is totally innocent. At least that's the way in Swedish courtrooms. I think it's the same everywhere. And that is a mental exercise that the judge has to do. Even though he's standing there, and that means that he got there somehow to this courtroom, you still have to think that this person is completely innocent. So you have to force this red dot here downwards to maybe 1% or something like that. That is some very low, not zero, because zero doesn't exist in this world, but very, very low. Okay, so he's presumed innocent. And then, at least with us, you have to consider the evidential strength, the total evidential strength, this combined likelihood ratio of all evidence that is presented in court. And in Sweden, what is not presented in court doesn't count. It's what's presented in court. And then you have to consider whether the arrow here, which direction it points. Of course, it can point in any direction and have strongly. Now I have a positive. You see, there is a lot of things speaking against Bob Smith here. And just part of this, both from the prosecutor and the judge, the forensic evidence is just a small part. Could be a big part or a small part of this. This is the total body of evidence. So it's the witness reports and everything. And here there is also a cutoff, of course. And this cutoff is this beautiful cutoff that is called beyond reasonable doubt. And I think that judges can talk for days on what is beyond reasonable doubt, because that is influenced by so many factors. But for each and every one of you, you have this cutoff somewhere. And if the dot here is above that cutoff, then you can make a decision which is, in this case, guilty. The verdict is guilty. And in fact, now I've illustrated, I think, the entire legal process in using Bayesian theory. Have you seen any equations? No. But I think you have seen a bit of logic. And I've also tried to, this is my final slide, you could also show this process in this way. And now we are looking at the different kind of propositions and the probabilities. And now we recognize this triangle. The judge is up there working at crime level, and also the prosecution, finally. But before that, there is a lot of things going on activity level, a lot of propositions, a lot of probabilities, and also source level. And here you can see also all the different parts of the legal chain. And the arrows there to the right illustrate that all through this process, there is, of course, a lot of communication going on here. There is not like a straight arrow that only moves in one direction. We have to communicate, we have to talk to one another, and we have to understand one another, and we have to understand each other's roles, like Jonathan also talked about. And with that, I hope I have left you with a little seed to think about. Thank you very much.
Thank you very much. Liels paldies Birgitai.
Thank you very much, Birgitta. We have some time left for questions, not as much as we hoped, but still we do have some time. And To make the procedure easier, everyone is kindly asked to use the microphone, and I would like to ask Jonathan and Birgit to take the places next to at the table in front of the room.
Es saprotu, ka jautājumi ļoti daudz.
I realize that there are many questions. Everyone is bursting now to ask their questions, so welcome. Your questions will be hard. Please digest everything that you just heard, because this is always or often the case that the judge wants to hear yes or no. And he's less eager to hear how the expert sees the events on that level, whether this person signed this document or he didn't sign it himself, and so on. I have a lot of questions which I had when listening to the presentation, but I have already discussed them with Jonathan myself, and I'm going to talk to Birgit about this too. But this concerns experts' vision or experts' perspective more. Perhaps you would be interested to hear how judges live in the UK and Sweden with possibly or very possibly or probably and very probably. And I would have liked to ask Jonathan, where is the border between strong support and possibility? I still do not know what to put in that H, whether it is strong or weak.
That depends significantly from where you started with your traditional scale. Because some organizations will start from the basis that possibly is quite a strong conclusion, whereas possibly to other organizations might be quite a weak conclusion. In trying to move away from those terms and moving into a standardized scale across Europe, we are trying to encourage all participants in forensic science to judge from the same page of a book. In my opinion, possibly would be quite a weak conclusion, probably would be stronger, highly probable would be stronger again. But we still, a lot of forensic science in terms of conclusions has never really been validated. So we don't quite know what these terms mean in different forensic areas. And that's certainly a piece of work that is being done at the moment. But in terms of where possibly stands, I would have possibly in at the weak or moderate level and not as a strong or extremely strong conclusion.
Could I comment on that as well?
Yes,
Yeah.
yes, please.
We used a verbal scale for many years. Our scale was initially verbal in 2004, and it turned out that the Swedish legal system, they tended to underestimate what you saw here as a +2, which actually is means that the results are more than 100 times more probable if the main hypothesis is true in relation to the alternative. They tended to see this as kind of weak. And it's still a problem, and it just underlines the importance of having events like this, where we all together discuss these issues, and we find a common ground of understanding. And that's also why we have introduced these definitions of what these our scale, different level, actually means in terms of numbers. And there are a lot of judges and prosecutors that says, wow, I didn't know that the +2 was that strong. So it is an important issue that you talk about this, and as Jonathan said, that if it varies between countries and between jurisdictions, we should strive to harmonize this across Europe so that possibly it's the same all over.
I think it was 2 years ago when the Dutch had the presidency of the EU, they called together a big conference in Amsterdam. And one of those aspects of that conference was pulling together legal, medical, forensic investigators all in the same room to talk about these types of things. One of them was certification and the need for a more standardized certification process in forensic science. But another one of them was very much how we work on collaborative exercises, proficiency tests. Those can only really work if we're all working and using a similar scale. Otherwise, you are comparing chalk and cheese, and it is very difficult to do that.
Jā, paldies. Laikam kļūst skaidrāk mazliet.
Thank you. Thank you. This casts some light on the issue. Everything is very well. We understand and use these tests well. We communicate between experts very well, expert to expert. But how to achieve common, unequal mutual understanding by judges, by prosecution, and by the defense lawyers, so that everyone would understand the scale, so that all the parties, all the stakeholders would understand the scale, as we experts understand, but what to do with our clients.
Events. I think you need to organize conferences, workshops, and you need to work with cases. You also need to involve prosecutors and lawyers and judges as teachers so that you teach these things together. Because it's not always easy for us, being lab rats and scientists, to speak the legal lingo, so to speak. We use the wrong words sometimes, and sometimes it's just that which is the problem. You need somebody to, you need to have a legal representative by your side that can explain these things in the legal terms. That is, I think that has been, at the moment we are teaching, when we do, we have courses for experienced judges in Sweden. We are doing it together with a law professor that is, he's an expert in evidential, how you present evidence and evaluate evidence in court. And he uses words that are quite new to us. And it's very good, because then we can come together as teachers, as instructors. So if you get a group together with people from different areas, maybe you are all sitting in here. I think you are. I mean, that's a very good thing to do.
Thank you, Birgit. Yeah.
Please, more questions. I got a little carried away because I am full of questions. I'm quite brimming with them. I know that there were some remarks from members of the audience while the presenters were making their speeches. So please speak up. My name is Saulis Vārpiņš. I'm an attorney at law. My question concerns the forensic expertise. You know that in Latvia this is performed only by forensic experts. But do you have experience in performing forensic expertise for other countries? And is it true that in your country you only accept your own domestic forensic experts or not?
You can start.
I gave evidence at the trial of a guy called Megrahi, the bomber on the Lockerbie plane over Scotland. That case was held in a Scottish court, and that Scottish court was held in Holland. Witnesses at that court were both lay witnesses, but professional experts as well. And they came from many different countries, different jurisdictions, and different legal processes. and they were entirely accepted by the court as being an expert, having provided sufficient credentials to demonstrate their credibility. So I've worked in legal systems where experts from other countries have been involved in evidence. The conference in Amsterdam 2-3 years ago was very much intended to look at a European certification program, so that the European certification program would allow an expert from one country to present in another country. A lot of MC laboratories, directors of MC laboratories, said that it was pointless and there was no need for it because they had their own register and their register should be acceptable across Europe. But that comes down to the local country's understanding of what that credential means. So I'm still an advocate of a European certification program for experts. Whether it will ever happen, I very much doubt in my time in forensic science. I very much doubt in my time as a British person in the EU that it will happen. But I would still very much be a strong advocate for a European certification program.
Yeah, and so are we. So we totally agree on this. We do quite a bit of second opinions to other labs. We also have other parties across Europe that are delivering data to us. We don't do, there are analyses that we don't do, we send them abroad. And then we are still responsible for the case, but we use the expert opinion of experts across Europe, and they could be at forensic laboratories, they could be university people, they could be companies, but we have the responsibility of the quality assurance of these subcontractors. And we have also testified in international cases, for instance, when regards to terrorism and things like that. We also have a collaboration with for instance, the tribunal in Hague when it comes to international crime, so various sorts. So it's and I think accreditation, certification is very important in this. Quality assurance. Then it's no problem to work across borders. Crime is across borders. Yeah.
Paldies. Jautājumi.
Thank you very much. Are there any more questions? My name is Bogdanska. I'm a prosecutor at the Riga District Court. I understand that in your country the probability is very important in forensic expert opinion. But have you ever had cases where you could not give any definite answer, where it was just 50-50?
Yes, absolutely. That's the zero in scale, when it's equally probable given either hypothesis. There are also cases, and that I didn't point out, that there is quite a lot of cases that we do when we don't need to do evaluative reporting, when we just report the facts. For instance, when we do drug analysis, then we report that this is amphetamine because there are criteria for amphetamine. There are also cases which are descriptive. We are asked to describe what's on a hard drive, for instance, then we describe that. Or they could be measurements. But there are also cases where the question is really on when there are hypotheses around around the material, but it's too difficult for us to do the evaluation. And there are many different reasons for that. And then we just report that we have tried to do, we have found these results, but it's not possible to do the evaluation, and we give the reasons for that. And one reason is that we simply don't have enough knowledge to evaluate it's unusual circumstances around the material, so we don't have the knowledge to assess any probabilities. That happens, yeah.
Just to give you a quick figure, a fact, I surveyed my working group, all of the European laboratories involved in handwriting, and we were asking about what conclusion scales the laboratory used. And from 35 different countries, I got 32 different conclusion scales. Some of those conclusion scales were what we call binary: yes, no, don't know. Some of them had up to 13 points on a scale. What all of those scales have will be a gap between the indeterminate and the lowest point on a scale where they can give some form of support to the courts, help to the courts in understanding the process. And in a binary scale of yes, no, don't know, the gap between don't know and definite is a huge area where we as scientists are not helping the court at all. And it is our responsibility to assist the court by evaluating the science that gives those points. In terms of giving evidence, I have frequently given evidence in court that's less than certainty. I can now quite happily sit here and say that for 27, 26 years, I've given evidence in court that hasn't been doing the scientific evidence full justice because I've been using a two-stage approach. It is only now that I'm beginning to understand logical reasoning and evaluative reporting better that I can assist the courts, I think now, in a better format. And that's by concluding this middle ground. And I think that is important.
Paldies vēl.
Thank you. Any more questions? I understand that we are ready to leave. No, there is one more question. We are not yet ready to leave. Good afternoon. My name is Richard Splotka. I represent the prosecutor's office of Liepāja city. I would like to talk about polygraph method, the so-called lie detector. What is your opinion on the veracity of the results provided by polygraph, and what are the potential alternatives in your practice?
I can answer that very simply. I don't use it. I have not used it. I don't know that it is used in the Scottish legal system at all anyway. I know that it is used elsewhere. Personally, I don't know what the validation and the process is for verifying the results. So I'm a bit of a skeptic, but a healthy scientific skeptic that says there might be something there, but you need to show me what it is.
Same in Sweden. I don't think, to my knowledge, it's not used, and it's considered to be very shaky indeed.
Thank you. So, one more question. Vēl viens jautājums, ņemot vērā.
Another question, taking account your answers. In your opinion, what is the quality of the Latvian forensic expertise system?
The lie detector, we take apart the lie detector. I think maybe you should look into that. As Jonathan said, there might be something there, and if you find something, maybe we can. I mean, somebody needs to look at it more. You mean, but your question is sort of the total system?
Jā, jūs kā, teiksim, eksperti.
Yes, you as foreign experts, what do you think about our system? Because you have had some glimpses of our system, and we believe your opinion will be neutral and more or less objective.
I think I know too little. But I know too little to say anything. I think just the fact that you are here today, and what I've heard today from the people who have spoken is very, very positive. In fact, this kind of gathering is, I don't know if we ever had it in Sweden, with all these parties coming together in the same room. So that is something that you are doing very, very, I mean, you have a very good starting point for doing something incredibly good.
I wouldn't want to comment on the Latvian legal system. I don't know it. In the same in the same way that I wouldn't comment on the Swedish or the Dutch or any other country. It would be totally wrong. But what I agree with and complete with Birgitta in that I have never sat in a room, certainly never presented in a room, where there is such a strong representation from the jurisdiction, from the legal, whether it be the judges, prosecutors, defense, forensic scientists. I've never sat in that room. I think if you're wanting to review internally your mechanisms and how things can be done, this is a fantastic opportunity for doing that. And I would echo, from what I've heard, the legal system seems to be consistent with others that I've heard about, but I wouldn't want to comment.
And I would like to, I mean, if you think that this, at the end of the day today, that you think this was a good idea, and that you are going away from here with new ideas and a lot of new thinking in your head, and you want to continue, then you should by all means do so. And we will copy you.
We are certainly, I've been working on a project in America, which is human factors. It's how forensic scientists cope with answering difficult questions, through to tiredness, through to a load of other factors that are human factors. And part of that, one of the main recommendations out of that project came down to the fact that lawyers and forensic scientists and judges need to meet on regular occasions so that we understand where each of us is coming from. Because we all come into this melting pot of a courtroom with different requirements, and quite often we don't know what those requirements are from the other people. But if you go in and you understand positioning, it makes life so much easier, and you can get rid of all of the personalities and you can start to concentrate on the scientific findings and the other evidence.
Thank you. Vēl jautājumi? Ir vēl viens jautājums.
Vispirms, paldies par interesantām prezentācijām.
First of all, thank you for the most interesting presentations. I'm a medical court expert, Andra Liepiņa. My question is, to what extent could we apply the bias theory for the analysis of causes of death in the expertises of the dead? Oh, this will take the entire lunch break. No.
I think you definitely can. I've worked quite a lot with forensic veterinary pathologists in Sweden, and also a bit with regular pathologists. But and I happen to be a medical doctor myself by training. So we tried to apply Bayes. They wanted to apply Bayes as we apply it in laboratory because they considered themselves as a laboratory. Then when we started investigating things, it turns out that an autopsy is really not, it's very much more like a crime scene investigation. So what we are doing now is that we're trying to apply the work we are doing on crime scene to the autopsy room. We haven't gotten as far yet, but that's one thing I would really like to do, because when you do an autopsy, you're actually formulating hypotheses based on what you find, or your findings in the process. And from that, you also formulate specific questions on specific tissues and samples that you send to the lab. And the lab then performs analysis very much the same way as we do in the lab, in the forensic laboratory. It is a forensic laboratory. It's just medical forensic laboratory. So there you can apply sort of the laboratory part of Bayesian thinking. But the actual process of finding the cause of death or in the autopsy room, that is really, to me at least, there we should apply the methods we use on the crime scene. So that's, if I get another 30 years, I will. But there is a lot of very, very exciting things to do there. Yeah.
Thank you.
Jā, paldies. Īstenībā tas ir.
Thank you very much. It's a very important question. I would very much like to see the scale when a question is asked whether the body injuries were caused in the circumstances which were described. Because presently, if someone answers, or the answer is might be, as an old police officer, I believe in it, to me it seems 50-50. Thank you very much to Jonathan, to Birgitta. And you can ask Jonathan questions during the lunch break. Birgitta will participate in the afternoon discussion as well. And now everyone is kindly invited to the lunch. And at 1 o'clock sharp, we expect you to be back in this room. There will be interesting presentations, including a presentation about construction.